May it please the court, I am Jekalicia Williams, and with me are my colleagues Celestial Hanley, Synovia Vaughn, and Michael Maloney. We appear on behalf of the claimant, Mr. John Liebert, who is present in court today.
Yes.
May it please you, my lord. My name is Angelique Liverpool, and with me are Imoyan Grant, Donicia Hendrickson, and Nayanta David of the Dean and Associate Law Chambers. We appear on the behalf of the defendants Kishan Claxton and Philip Nisbet. They are in court.
Yes. Yes. The claimant is ready to proceed.
My lord, before the court is the claimant's claim seeking relief as a result of the gross negligence of the first defendant, which caused the claimant serious injury, loss, and damages. With the permission of the court, may I proceed to present my opening statement?
Yes, you may.
May it please you, my lord, we intend to prove that the first defendant, Mr. Liebert, is liable for the damages caused to Mr. Liebert's vehicle and the injuries he sustained as a result of a car accident that took place on the 28th of April 2018. On the day of the accident, Mr. Liebert was driving his pickup truck on the island's main road in the Newcastle area. He stopped on his side of the road, the left side, the mountain side, to cover the back of his pickup truck from the rain that was about to fall. The first defendant came along on Mr. Liebert's side of the road at a fast speed and collided head-on with Mr. Liebert's vehicle, climbing on top of Mr. Liebert's truck. Because of this, Mr. Liebert was pinned inside his truck and could only be freed by the fire department. The claimant suffered tremendous pain as a result of the accident. The hasty and reckless driving of the first defendant caused the claimant to sustain injuries in his hip and right leg. This will be borne out in the evidence of Dr. Theodore Watson. We intend to call two additional witnesses, the claimant himself, Mr. Liebert, who will tell you about the injuries he sustained and how the accident has affected him financially and physically, and Mr. Clary Pringle, a passenger in the Mr. Liebert's vehicle, who would give his account of the accident. As a result of the accident, our client has not been able to return to work on his farm. His farming business has suffered financial losses, and his truck was total beyond repair. He has also incurred significant medical expenses. During this court of trial, we would adduce evidence through our witnesses, Mr. Liebert and Mr. Pringle, to support our case that the first defendant was driving on the wrong side of the island's main road. The issues to be decided on are whether the claimant's injuries, loss, and damages were caused by the negligence of the defendant, whether the defendant's damage was caused by the negligence of the claimant, and whether the defendant is liable to the claimant for the relief sought in his claim, and whether the claimant is liable to the defendant for the relief sought in his counterclaim. My lord, here ends my opening address. My lord, I wish to call our first claimant, Mr. Liebert. Excuse me, Judge. Can the witnesses be excused outside?
Pardon me?
Can the witnesses be excused outside? Or the other witnesses be excused outside?
Yes.
Sweet. I swear that the evidence that I shall give to the court shall be the truth, the whole truth, and nothing but the truth. So help me God.
Good afternoon, Mr. Liburd.
Good afternoon.
Please state your full name for the court.
My name is John Liburd.
And please state your address.
I live at Cuddock Road, St. Thomas's Parish, Nevis.
What is your occupation?
I'm a farmer.
Do you recall the date 28th of April 2018?
Yes, I recall.
Where were you going on that day?
I was on my way to my farm in the Charlestown area.
Who owns the vehicle you were driving?
I own it.
And do you mind telling the court what type of vehicle it is?
It was a 2018 Dodge Ram pickup truck.
What side of the road were you traveling on?
I was on the left-hand side, the mountain side.
And can you describe the scenery on the side of the road you were driving on?
Well, that side of the road was surrounded by green, lush green vegetation.
Was there anyone traveling with you?
Yes, Mr. Kerry Pringle.
And what is Mr. Pringle's occupation?
He's a farm help.
Why was Mr. Pringle traveling with you?
He was going to help me offload the feed off of my pickup.
And can you explain where in the truck Mr. Pringle was sitting?
He was in the back because I had some important stuff on the front seat.
Mr. Liburd, you say you were traveling along the left side of the road, the mountain side of the road, heading to town. Did you notice anything whilst you were driving?
Yes, the place looked a bit overcast. So I stopped because I wanted to cover the feed in the back.
Why? What do you mean you stopped?
I slowed down and stopped the vehicle.
On what side of the road did you pull over on?
The left-hand side.
You said your car was stationary on the mountain side of the road. Did anything happen while your car was stationary?
Yes, I heard the screeching of wheels coming around the corner.
And could you see around the bend?
No, I couldn't.
Approximately how far from the bend was your truck at this time?
About 50 feet.
So who came around the bend?
The first defendant.
And how was the Jeep being driven?
Very quickly.
What side of the road did the Jeep come around the bend on?
It came around on my left, his right, which is the mountain side.
And where was the Jeep heading?
In the opposite direction, towards me.
My lord, sorry for interrupting, but may the witness speak a little slower so I can take notes.
Yes, I think I would appreciate that as well. Let's go a little slower.
Were you able to do anything when you saw the Jeep coming towards you?
No, I could only brace for impact.
I'm sorry, I didn't hear that.
I could only brace for impact.
Where did the vehicle impact your truck?
It hit me head on and it jumped on top of the hood of my truck.
Do you recall what happened immediately after the impact?
Well, I can't recall every single detail, but I heard someone yelling, "Get him out, get him out."
Were you able to see Mr. Pringle after the impact?
No, I wasn't able to see him.
Or were you able to hear Mr. Pringle after the impact?
No.
So, can you describe your feelings in the moment immediately after the impact?
Well, I was in a lot of pain.
And can you tell the court where exactly you were feeling this pain?
In both legs.
Besides Mr. Pringle and the first defendant, were there any other persons at the scene of the accident?
I couldn't tell.
Were you able to get out of your truck?
No.
Okay. Do you recall being freed from your vehicle?
No, I don't recall.
Why don't you recall?
Because I blacked out.
So, did you see Mr. Pringle even before you lost consciousness?
No, I didn't see him.
Were you able to move in the truck?
No, my legs were pinned.
And where were you when you regained consciousness?
I was in the Alexandra Hospital, Nevis.
And who was there when you woke up in the Alexandria Hospital?
Dr. Theodore Watson.
And who was your attending doctor at this time?
Dr. Theodore Watson.
How long did you stay at the Alexandria Hospital?
For less than a day. And then I was flown out to the Fracture Orthopedic Clinic in Port of Spain, Trinidad.
And who was your attending doctor there?
Dr. Ramdeen.
Mr. Liebert, are you still under physician's care?
Yes, I am still under his care.
Which physician do you see?
I can't remember his name at the moment.
Can you tell the court how much you spend on physical and medical treatments?
I spend $300 EC per week to go to the therapist's office.
Do you recall how long you stayed in the Arthur Hospital in Trinidad?
I stayed there until the 19th of May, 2018.
So you were in the hospital for just 1 month. Who ran your farm during that time?
Mr. Dave Major.
And did you pay Mr. Major?
Yes, I did.
How much did you have to pay Mr. Major?
$3,000 per month.
Have you returned to work on your farm?
No, I'm not. I'm physically unable to work on the farm.
And does Mr. Pringle still work for you?
No. Since the accident, the farm doesn't make enough money to keep him on, so we had to let him go.
Tell me about your vehicle. Is it now back on the road?
No, it's totaled.
So how do you get around now?
I have to call on my nephew to carry me wherever I want to go.
Mr. Liebert, do you recall giving a statement in regard to this matter?
Yes, I do.
If you see the statement, would you be able to recognize it?
Yes,
How would you be able to recognize it?
by my signature.
My Lord, with leave of the court, may the witness be shown his witness statement.
Yes. Are there any objections to the tendering of the witness statement?
No objections, my lord.
Yes, very well. You may proceed.
Yes, this is my signature.
And do you adopt this statement to be true and correct?
No, there are a couple typographical errors.
And what are those errors?
The actual cost of the wheelchair is $3,000 EC, and the actual cost of each therapist visit is $300 EC.
Let the record state that the witness has adopted the statement with amendments to be true and correct. No further questions, my lord. My lord, our witness, Mr. Liebert, is now ready for cross-examination.
Yes.
As a reminder, my lord, my name is Imoyen Grant, and I will now cross-examine the claimant. Mr. Liebert, do you recall the 28th day of April 2018?
Yes, of course I recall.
And on that day, did you drive along the Island Main Road in the vicinity of the Vance W. Amri International Airport?
Yes, I did.
Mr. Liebert, are you the owner of...
Counsel, can I remember the objection you made a while ago? Yes. So. Yes, so we just go a little slower. Okay, I'm trying to write.
Yes, my lord. Mr. Liebert, are you the owner of vehicle P876?
No, I'm not.
Were you driving P876 on the day in question?
Yes.
Mr. Liebert, how long have you been driving for?
For approximately 20 years.
So you are an experienced driver.
Yes, I am.
Do you consider yourself to be a prudent driver?
Prudent. I'm not familiar with that word.
A fit, eligible, law-abiding driver?
Yes, I am.
Are you aware of the laws of the road?
Yes, I am.
So you do know that you're supposed to be mindful of other road users other than yourself.
Yes, I know that.
On the 28th day of April, where were you driving to?
To my farm in the Charleston area.
And Mr. Liebert, where were you driving from?
From over Butlers.
It is in your evidence that you stopped to buy feed for your farm. Is it true?
Yes.
Who, may I ask, did you buy the feed from?
Mr. Chumney.
So, Mr. Liebert, how much money did you pay for this feed?
$300.
Was anybody driving with you at the moment? Was anybody driving with you at the moment of the collision?
Yes, Mr. Kerry Pringle.
And where was Mr. Pringle located?
In the tree, in the back.
So, Mr. Liebert, how often do you drive in the vicinity of the Vance W. Amri International Airport?
Once every 2 weeks.
So you are familiar with the bend in the road?
Yes, I am.
While driving along the Island Main Road, were the windows of your pickup down or up?
Yes, they were down.
You said while driving you were concerned about Mr. Pringle getting wet and your feet, right?
I was concerned about the feed getting wet, not Mr. Pringle.
Mr. Library, what made you think that it was going to rain?
The place was looking overcast, and a lot of dark clouds were in the area.
So, you weren't concerned. Mr. Library, when you thought it was going to rain, what did you do?
I slowed down the vehicle and stopped.
Did Mr. Pringle yell to you that look? Did you yell to Mr. Pringle that it looked like it was going to rain?
Yes, I did.
So therefore, you were distracted.
No,
So you were multitasking. You were yelling and still driving at the same time.
yes.
Mr. Library, if the rain had fell, would it have destroyed your field?
No, but it would have caked it up and make it hard to work with.
So, Mr. Library, is it because you were concerned you pulled over at a bend?
No, just before the bend. A good distance before the bend.
Stay for the coach, how far from the bend, please?
50 feet from the bend.
Mr. Library, did you take any steps to alert any vehicle that you were going to pull over?
No, because I checked behind before I stopped and no vehicle was coming behind me.
So, you didn't alert anybody? Not even the oncoming vehicles?
No vehicles were oncoming at the moment.
So, Mr. Library, you stopped before the bend, so you could see around the bend?
No, I couldn't see around the bend.
So how did you know that there wasn't any oncoming vehicles?
Well, no vehicle should be coming in my lane from that direction.
Mr. Library, whose lane?
My lane, the left-hand side, mountain side.
Mr. Library, did you ensure that the road was clear?
Yes, I did.
Mr. Library, are you familiar with the speed limit in that area?
Not quite.
Can you state for the court what is the speed you were going prior to the accident, the collision?
I wasn't moving at the time of the collision. I had already stopped.
So, Mr. Library, did you get out of the way because you thought it was going to rain? You thought?
Get out of the way? No. I just told you I slowed down the truck and stopped because I wanted to cover the field in the back. I had no time to get out of the truck.
So, Mr. Library, may I ask, how old are you?
40 years.
Mr. Library, in your witness statement, you say you're 50 years old.
I said that?
You're contradicting yourself.
Well, that was a typographical error, my dear. Sorry about that.
You know that? At the time of the accident, were you using your prescribed drugs?
No.
So you went against your physician.
Well, I was rushing that morning, so I didn't have time to take my drugs.
So you might have been a little woozy, a little.
Sorry, we're objecting on relevance. Relevance to the matter of the accident.
Yes. Why are you saying it's not relevant?
Yes, Mr. Liebert is diabetic, but he is not that critical that he needs medication.
Very well.
Excuse me, my lord. She cannot give medical evidence. Counsel cannot give medical evidence. For
Yes.
the witness, sorry.
Well, the witness admitted that he's taking medication and he left in a rush, I think that's what he said. So you're entitled to ask him questions in relation to that. So you can proceed.
Mr. Library, can you state for the court what are you taking medication for?
Diabetes.
That's the only disease you're suffering from?
Yes.
So, isn't it true that you suffered from hypertension?
Oh, yes, I do. Sorry, I forgot about that. I forgot about that.
So, Mr. So, Mr. Library, isn't your medication important to you?
Yes. But one of the side effects of that medication is to make me woozy. So I don't see if I don't take the medication, how I will still be woozy. I also understand that.
Excuse me? Thank you. Mr. Library, isn't your body accustomed to the medication, is it?
Not quite. Because I have left home a number of mornings without taking the medication. So this isn't the first time.
So you were taking risk.
Yes.
You were taking risk.
Yes, I was.
So you took risk with your medication and still on the road? You took risk by not taking your medication. So didn't you endanger other road users?
No.
Mr. Liebert, but you didn't take your medication. Mr. Liebert, I am putting it to you that you did endanger the other road users.
No, I didn't
Thank
endanger
you.
anyone.
Thank you. Mr. Liebert, may I ask, what is the model of your pickup truck?
Dodge, a 2018 Dodge Ram pickup truck.
And when did you purchase this pickup truck?
Earlier this year.
Mr. Liebert, before the accident, when was the last time you took your vehicle to the mechanic?
2 months prior to that. 2 months prior to the accident.
And Mr. Liebert, who did the valuation of your pickup truck?
My mechanic, George Simpson.
Is that the mechanic you are accustomed to go to?
Yes.
Mr. Liebert, what was the total after the collision? of
What?
The pickup? The total damages after the collision.
Total damages? Well, $450,000 because I had to buy a whole new pickup. Well, I will have to buy a whole brand new pickup. It was totaled.
How much money did you make from your farm when you were working on it, Mr. Liebert?
$4,000 per month.
The accident occurred in April, right?
Yes.
And how long has Mr. Dave Major been working on your farm?
For about a month now.
Mr. Liebert, have you made any attempts to replace Mr. Major?
To replace Mr. Major?
Yes.
He's still currently employed at my farm.
But did you make any attempts to replace Mr. Major?
Mr. Major? There's no need to replace Mr. Major.
Yet you said in your witness report that you are making a loss on your farm because of Mr. Major.
Yes, but other than me, he's the best agriculture man we have in the island of Nevis. So there's no other person that can do a better job than him.
Mr. Liburn, so your farm has been losing $4,000 per month, as said in your witness statement, and you have made no effort to replace Mr. Major.
No, I couldn't.
Well, Mr. Liburn, you stated before you only paid him $3,000 a month. Mr. Liburn, I am suggesting to you that on the 28th day of April, you failed to execute proper road safety.
That's not accurate.
You pulled over onto the path of Mr. Claxton, collided with P345.
No, I didn't.
You drove onto the wrong side of the road without giving any oncoming traffic alert.
No, I didn't do that.
You did not brake, steer, or swerve to avoid the collision.
I was stationary,
I
so
am suggesting that your failure to drive with due care caused the injury to you and Mr. Claxton.
that's not true.
I'm also putting it to you that your negligent driving caused damages to PA 345 totaling $100,000.
That also isn't true.
And I am also putting it to you that your negligent driver caused Mr. Nisbet in the expense of renting another vehicle in the amount of $40,000.
No, I didn't.
No further questions, my lord.
Yes. Any re-examination of the witness?
Yes, re-examinations, my lord. Mr. Liburn, you said you were under physician's care. Are you still under physician's care?
Yes, I am still under physician's care.
And can you tell the court what type of treatment do you receive?
Therapy treatment once a week.
And who's the owner of the vehicle that you were driving?
I am the owner of the vehicle.
No further questions, my lord.
Yes, thank you very much, Mr. Liburn. You can have a seat. Yes, who is the next witness for the claimant?
Good afternoon, my lord.
Good afternoon.
My lord, with the leave of the court, I would like to call the second witness, Mr. Kerry Pringle.
Yes, very well.
Yes, I see. I swear that the evidence I shall give to the court shall be the truth, the whole truth, and nothing but the truth. So help me God.
Good afternoon.
Good afternoon.
Can you please state your name for the court?
My name is Mr. Kerry Pingle.
And where do you live?
I reside at Newcastle.
What is your occupation?
I am a farmer, I'm a laborer.
Do you recall what happened on the date, the 28th April 2018?
Yes, I was in an accident.
Do you recall exactly what happened on that day?
Yes. I was riding in the back of Mr. Labert pickup truck, traveling to town, and sitting on some bags of feed we had bought on the way to the farm. And I felt when Mr. Labert pulled over. Almost immediately after he pulled over, there was a crash.
Okay, so who you said was driving the vehicle at the time?
Mr. Labert,
What is your relation with Mr. Liebert?
he was my former boss.
Okay. What direction were you facing at the time?
Well, I was facing the opposite direction. My back was turned to the driver.
And can you please remind me what side of the road you were driving on again?
We were driving on the mountain side of the road.
Did you hear anything after the collision?
Yes, I heard when Mr. Labert crying out for help, and I heard when someone yelled, "Get him out of the truck."
So did you see anything after the collision?
Yes, I saw. Yes, almost immediately after I heard Mr. Labert crying for help, I jumped off the pickup truck and I saw Mr. Labert pinned inside of the vehicle. And I also saw the fire brigade truck and officer that arrived at the scene and cut the truck to get Mr. Labert out. And I also saw when the defendant moved his vehicle from the mountain side of the road to the airport side of the road.
What did you do after the collision?
Well, I was traumatized. I didn't know what to look. I didn't want to make Mr. Labor's situation worse, so I left and I walked home.
Mr. Pringle, do you recall giving a witness statement?
Yes.
And if I show you the witness statement, how can you recognize the witness statement?
My signature is on it.
My lord, with leave of the court, may the witness statement be shown to the witness? Mr. Pringle, is that the statement you gave?
Yes.
And how can you recognize the statement?
My signature is on it.
Okay. Do you adopt this statement to be true and correct?
No, there was a typographical error where I referred to Mr. Labert as Mr. Brown because his mother's family name is Brown. So that's the name I usually call him on the farm, Mr. Brown.
Okay. Let the record state that the witness has adopted the statement as true and correct. My lord, this is the extent of Mr. Pringle's examination. With amendment, sorry.
Yes.
My lord, our witness, Carrie Pringle, is available to be cross-examined.
Yes, very well.
May it please you, my lord, my name is Danicia Hendrickson and I will be cross-examining Carrie Pringle. Mr. Pringle, on the day in question, Mr. Pringle, on the day in question, you were in the back of Mr. Lybert's pickup truck?
Please repeat.
On the day in question, you were at the back of Mr. Lybert's truck?
No, I wasn't.
Mr. Pringle, in your witness statement, you stated that you were to the back of Mr. Leibert's pickup truck.
Yes, I was to the back of Mr. Leibert's pickup truck.
And yet, I just asked you on the day of question, were you to the back of Mr. Leibert's pickup truck?
I was to the back of Mr. Leibert's pickup truck, yes.
What type of day was it?
Well, I wasn't paying attention to the weather. But I think it was a rainy day because Mr. Leibert yelled to me that it looked like it was going to rain.
You were to the back of the pickup truck, but yet you don't know if it was going to rain?
I wasn't paying any attention to the weather.
From the time you got onto the pickup, from when Mr. Leibert bought the feed, how long would you say it was?
Well, it's about a couple minutes. I'm not sure how long it was, but it was for a couple minutes.
So would you say 5 minutes?
Maybe more.
How many bags of feeds were in the back?
I didn't count the bags of feed, but there was a few.
And how long were you riding on the back of the pickup from the time Mr. Leibert bought the feed to when the collision occurred?
For a few minutes.
So would you say 5 minutes?
Maybe more.
Mr. Pringle, I am putting it to you that you are not telling the truth.
I am telling the truth.
You mentioned that Mr. Leibert yelled to you that it was going to rain.
Yes, he yelled to me like it would look like it was going to rain.
And how did Mr. Leibert yell that it was going to rain? With
Well-
urgency?
Please repeat.
How did Mr. Leibert yell that it was going to rain? Was it with urgency?
Yes. After we pulled over, he yelled to me that it looked like it was going to rain.
So he yelled as if he was in a hurry to let you know that it was going to rain.
Well, I wouldn't say it was a hurry, but he just yelled to me that it looked like it was going to rain.
Mr. Pringle, can you please answer the question?
Well, I would think so because it looked like it was going to rain, and since the bags of feed were to the back of the pickup truck, I would think that he wanted to cover the bags of feed. So yes, I would think he was in a hurry to cover the bags of feed.
Did Mr. Leibert stick out his head out the window and yell at you?
No, I don't remember him sticking out his head out of the window. I only heard his voice because I couldn't have seen whether his head was out of the window because remember my back was turned to the driver.
But you heard him.
Yes, I heard when he yelled to me.
Is it your evidence that Mr. Leibert pulled over?
Yes. He pulled over.
Did he yell at you in the process of pulling over or after he had pulled over?
After he had pulled over, he yelled to me that it looked like it was going to rain.
But, Mr. Pringle, in your witness statement, you said that he yelled at you, he was pulling over and he yelled at you that it was going to rain. So which means that he was in the process of Mr. Pringle, did Mr. Leibert yell while pulling over?
Mr. Leibert yelled, it looked like it was going to rain. After he had pulled over, I felt him pull over.
Indulgence, my lord. Can the witness be shown his witness statement?
Yes, he can.
Can you please read paragraph 4 and 5 of your witness statement?
I felt when Mr. Brown pulled over. He yelled to me that it looked like it was going to rain. I don't know if it was going to rain as I was not paying any attention to the weather. Almost immediately after I felt him pulling over, there was a big crash and I was flung off the feedbacks and nearly fell out of the pickup truck. I was not hurt, but I was afraid because I didn't know what was going on.
Which side of the road was Mr. Liebert pulling over?
Mr. Liebert pulled over on the mountain side of the road.
Mr. Pringle, did Mr. Liebert yell at you while he was pulling over?
Mr. Liebert yelled at me after he pulled over.
My lord, objection please. The witness was asked that question and he answered that question.
Yes. Yes, I think that question has been answered. So we can move on from there.
Mr. Pringle, in your witness statement, you said that Mr. Liebert was yelled at you while pulling over. And yet, you come here and say that he pulled over, then he yelled at you?
Paragraph 4 said, I felt when Mr.
My
Brown...
lord,
Yes.
Paragraph 4 clearly states that I felt when Mr. Brown pulled over and he yelled to me that it looked like it was going to rain. So he yelled to me, it looked like it was going to rain after he pulled over on the mountain side of the road.
Isn't it true that he was pulling over to Mr. I will move on, my lord.
Yes.
Isn't it true that he was pulling over to Mr. Claxon's side of the road?
No.
What did Mr. Liebert do before pulling over?
Mr. Liebert, well, please repeat that question, please.
What did Mr. Liebert do before pulling over?
Well, he was driving his pickup truck.
Did you hear Mr. Liebert blow his vehicle horn?
Please repeat.
Did you hear Mr. Liebert blow his vehicle horn?
Blow?
Yeah.
I don't understand that question.
Beep.
No.
Did you see any oncoming vehicles before Mr. Liebert started pulling over?
No.
How soon after Mr. Liebert started pulling over you heard the big crash?
Please repeat that question.
How soon after Mr. Liebert started pulling over you heard the big crash?
It was soon after he pulled over.
Are you familiar with the area in the vicinity of the Vance Amri International Airport where the collision occurred?
Yes.
How often would you say you use that road?
Well, maybe once a week, twice a week. Not sure. I frequently use that word.
So you are familiar with the bend in the road?
Well, of course.
Have you seen a bend in the road in the vicinity of the airport?
Please repeat that question.
Have you seen a bend? Are you a driver, Mr. Pringle?
I didn't hear that question.
Are you a driver, Mr. Pringle?
No, I'm not a driver.
What distance would you say Mr. Liebert was from the bend when he started pulling over?
Maybe a few meters.
How many?
I'm not sure.
Mr. Pringle, can you please give me an estimate?
I cannot give you an estimate. It was just a few meters.
Did you see the other vehicle driven by Mr. Claxton?
No, remember, my back was turned to the driver. I was facing the opposite direction. So that means I can't see anything coming.
So you didn't see the accident?
No, I felt the crash.
Mr. Pringle, I am putting it to you that Mr. Liebert was the cause for the collision.
Mr. Liebert wasn't the cause of the collision.
I am putting it to you that Mr. Liebert pulled over onto Mr. Claxton's side of the road.
No, Mr. Liebert pulled over on the mountain side of the road. His side of the road.
I am putting it to you that Mr. Liebert's truck was not on his side of the road after the accident.
Mr. Liebert's truck was on his side of the road before and after the accident.
Mr. Pringle, you're not speaking the truth.
I am speaking the truth.
No further questions, my lord.
Yes, any re-examination of the witness?
No re-examination, my lord.
Thank you. So you can have a...
Thank you.
Yes, who is the next witness for the claimant?
My lord, with the leave of the court, I would like to call the third witness, Dr. Theodore Watson. Please state your name for the court. Oh, sorry.
Yes, just a second.
Excuse me? Yes, I swear that the evidence I swear that the evidence that I shall give to the court shall be the truth, the whole truth, and nothing but the truth. So help me God.
Yes, you may proceed.
Please state your name for the court.
Dr. Theodore Watson. Dr. Theodore Watson. Sorry.
Please state your address.
Hamilton Estate.
What is your occupation?
I am a registered medical practitioner.
How many years have you been practicing medicine?
For 25 years now.
Dr. Watson, can you tell us your qualification?
Well, I have a Bachelor of Surgery degree and a Doctor of Medicine degree from the University of the West Indies.
Where is your office located?
In the Nevis Island Administration Clinic at the Alexander Hospital in Charlestown.
Do you recall the date, April 28, 2018?
Yes, that was the day that I was called to the emergency room to attend to Mr. Liebert.
When you saw Mr. Liebert, did you make any notes?
Yes, I did.
Do you recall preparing a medical report in regard to this matter?
Yes, I do.
You said you made notes on examining Mr. Liebert. Did you use these notes to prepare the medical report?
Yes, I did.
If you were to see this report, how would you be able to identify this report?
By my signature.
Dr. Watson, do you have the report with you today?
Yes, I do.
When did you prepare the medical report?
I prepared the report on the 14th of June, 2018.
My lord, with the leave of the court, may the witness report be shown to the witness?
Yes. Is there any objection to the witness having sight of the medical report?
No, my lord.
Very well. You may proceed.
My lord, with the leave of the court, may the witness be allowed to refresh his memory from the report?
Yes, very well.
Can you please tell the court what tests you carried out on Mr. Liebert?
Well, I conducted an X-ray, a CAT scan. I also ran a blood test. I also checked his blood pressure and physically examined his skeletal structure.
On examining Mr. Liebert, what condition was he in?
Well, he sustained a fracture of the posterior actibular, which is a break in the ball and socket of the hip. He also had a fractured neck of femur, which is the top of the femur in the leg. He also had a dislocated hip joint, a fracture to the mid-shaft of the femur, a fracture to his right patella, and a fracture to the right medial malleolus, which is the inner part of the ankle, along with the gloving of his ankle, of his right ankle, in addition to anterior capillar disruption.
Did Mr. Liebert say anything to you while you examined him?
Yes, he described to me where was hurting him.
How long did Mr. Liebert remain under your care?
Just for a day.
What happened next?
Well, I made arrangements so that Mr. Liebert can travel abroad for orthopedic and vascular surgery, evaluation and treatment in the fracture and orthopedic clinic in Port of Spain, Trinidad.
Why was Mr. Liebert transferred to Trinidad?
Well, we didn't have the necessary equipment here to deal with his severe injuries, so he needed to be transferred to a different hospital that had the necessary equipment to deal with him.
After Mr. Liebert was transferred to Trinidad, did you see Mr. Liebert again?
No,
Did you hear from Mr. Liebert again?
no. But his attorney requested a medical report, on his behalf.
Do you recall giving a witness statement in regard to this matter?
Yes, I do.
How would you be able to identify this witness statement?
By my signature.
My Lord, with the leave of the court, may the witness statement be shown to the witness?
Yes, very well.
Do you adopt this statement to be true and correct?
No, I noticed a few errors in the dates. The date on which the witness statement was written should be changed from the 1st of July 2018 to the 25th of July. And also the date in which the medical report was written should be changed from the 14th of June 2018 from the 3rd of June 2018 to the 14th of June. And also the date that Mr. Liebert was transferred to the hospital should be changed from February the 15th, 2009 to the 29th of April 2018.
Do you adopt your statement as true and correct with these amendments?
Yes, I do.
Let the record state that the witness has adopted the statement with amendments as true and correct. No further question, my Lord. My Lord, may the witness be allowed for cross-examination.
Yes. Cross-examination.
Excuse me, my lord. Can my colleagues be excused for refreshments?
Yes, maybe.
Call of nature. Nature.
I'm sorry, I can't hear you
Call
clearly.
of nature.
Yes, so we don't want to leave nature calling, do we? So your colleague might be excused at this point, yes.
Good evening.
Good
Just
evening.
a reminder, my lord. Were
Yes,
you
go
saying
ahead.
something?
No, go ahead.
Just a reminder, my lord. My name is Angelique Liverpool, and I will be cross-examining Dr. Watson.
Yes.
Dr. Watson, how long have you been a practitioner of medicine?
For 25 years.
So you would consider yourself a prudent doctor?
Well, not to toot my own horn, but
Yes or
I will
no,
say
Dr. Watson?
I will say yes.
Yes?
I will say yes.
On the 20th day of April 2000, do you have any prior relationship with Mr. Liebert?
No, not really.
Did you take any pre-existing history of the patient?
No.
So, some of these injuries could have been there before, right?
Well, no.
No. Okay. Dr. Watson, are you an orthopedic doctor?
Yes.
I thought you were a practitioner of medicine.
Well, I
Those are two
Spec-
different occupations.
I specialize in the area that you mentioned, but I also help in that area as well.
But you are not a professional orthopedic doctor, is that correct?
Well, the doctor that was scheduled.
Yes or no, Dr. Watson?
No.
No? But yet you consider yourself the right person to give evidence for Mr. Liebert, seeing that you're not an orthopedic doctor?
Well, I am a well-rounded doctor, so I can speak on his injuries.
So are you sure that these injuries happened to Mr. Liebert?
Yes, I am certain.
Did you take notes contemporaneously to the examination? As in, did you take notes the same time?
Yes, I did.
Did you take notes of the patient's past medical or surgical history?
Well, from his past medical.
Yes or no, Dr. Watson?
Yes, I did.
Can you please show that to the court?
I don't have it with me at the moment.
Is it possible that you didn't take it?
Yes, I did take it.
Did you take notes? Do you have any notes related to the patient's family history?
No, I don't.
Do you have any knowledge of whether Mr. Liebert had past orthopedic problems?
No.
So it is possible that these injuries may have come from a pre-existing condition.
No, it is not possible.
But you don't know his past history, if he had orthopedic problems.
If you would have allowed me to explain.
It's just a yes or no question, Dr. Watson.
Yes.
Do you have any notes related to your examination or investigation process?
Yes, I do.
What tests did you carry out on Mr. Liebert?
Well, as mentioned, I carried out a X-ray, a CAT scan. I also ran a blood test. I checked for his blood pressure, and I physically examined his skeletal structure.
Thank you. Dr. Watson, were you aware at the time of the collision that Mr. Liebert was on medication for hypertension and diabetes?
Yes.
Then why wasn't it mentioned in your witness statement?
Because it did not pertain to the specific matter of his injuries.
Dr. Watson, how was this medical report drafted if you had no notes on his past surgical or medical history?
It was drafted on his current condition.
Did you draft the report yourself?
Yes, I did.
Is your name on that report, Dr. Watson?
Yes, it is.
Did you sign that report, Dr. Watson?
Yes, I did.
Dr. Watson, wouldn't you say that it was a wide gap from the time you saw Dr. Watson and made the report? It was a 1 month period that you saw Mr. Liebert and made the report.
Yes, it was.
It was a wide gap.
Well, no, because of the response from the other hospital, I couldn't do anything but to wait on their response.
So it's a usual thing to write a report on a patient 1 month later?
Well, depending on the circumstance and how the injuries and how fast they are evaluated.
So was that a yes or a no?
You asked me how it.
You did not state any disabilities in your report, Dr. Watson. Did you?
No.
You said in your report that there was advisory for daily physical therapy. Advisory meaning what? Optional? Suggested?
Well, due to his severe injuries and his condition, the best thing for him would be to constantly be on therapy.
And you said likely to need a wheelchair, which means it is possible and it isn't possible that he needs a wheelchair.
Well, from his injuries and where they were, it would have required for him to need a wheelchair, but that was if he had the necessary money to obviously get a wheelchair.
Dr. Watson, the injuries did not require physical therapy or a wheelchair because it was only suggested, correct? It was just suggested that he might need it?
The injuries he
Yes
sustained.
or no, Dr. Watson? Suggested? Yes, it was suggested.
The injuries he sustained.
Yes or no, Dr. Watson?
No.
No? So he doesn't need them now?
Yes, due to his condition, obviously, he was needed that type of assistance.
Dr. Watson, in your witness statement, never mind. No further questions, my lord.
Yes, any re-examination of this witness?
Yes, my lord. Re-examination, please. What was the purpose of his x-ray?
The purpose of his x-ray was to see where exactly he sustained injuries and to see if he had any fractures.
Can you tell all from new injuries from the x-ray?
Excuse me?
Can you tell all from new injuries from the x-ray? Can you tell all from new injuries from the x-ray?
If I can tell old?
Yeah. All from the
Yes.
Were the injuries you describe in your report fresh?
Yes, they were.
No further question, my lord.
Thank you very much, Dr. Watson. You can step down now. Yes, are there any more witnesses for the claimant?
No, please, my lord.
So that's the end of the claimant's case.
Yes, please, my lord.
Excuse me, my lord. May it please you, my lord. I'd wish to, with your permission, I'd like to read my opening statement.
Yes, you may.
On the 20th day of April 2018, Mr. John Liburd and Mr. Kishan Claxton was involved in a terrible vehicle accident, resulting in personal injuries and extensive damage and loss, as claimed by the parties. Mr. Claxton's evidence today is that he was driving motor vehicle PA 345 owned by Mr. Nisbet, our second defendant, in the vicinity of the Vance W. Amory International Airport in Newcastle. You will hear Mr. Claxton say that he came around the bend and saw Mr. Liburd driving his pickup truck P876 speeding towards him on the wrong side of the road. You will hear Mr. Claxton say that the claimant drove into his path, made no attempts to stop, swerve, or maneuver his vehicle to avoid the collision. You will hear from our second defendant that the damage caused and claimed as a result of the negligence of the claimant, Mr. Liebert, in the amount of $140,000. In support of our defense and counterclaim, we intend to call two witnesses, Mr. Kishon Claxton and Mr. Philip Nisbet. The evidence of Mr. Claxton in particular will show that the accident and subsequent injuries, damage and loss was caused by the negligence of the claimant due to their own negligence and failure to drive with due care and attention. The defendants will therefore ask this honorable court at the end of this case to dismiss the claims filed by the claimant and reward the judgment to the first and the second defendants on the counterclaim with cost. May it please you, my lord.
Yes. You ready with your first witness?
May it please you, my lord. My name is Nayante David, and I will now do the examination in chief of Mr. Kishon Claxton.
Yes.
My lord, the defense wishes to please call Mr. Kishon Claxton.
Yes.
I do sincerely and declare and affirm that the evidence that I shall give to the court shall be the truth, the whole truth, and nothing but the truth.
Good afternoon, sir.
Good afternoon.
I will ask you a series of questions. Please speak loudly, clearly, and slowly, as His Lordship will be taking notes. Sir, can you please state your name for the court?
My name is Kishon Claxton.
What is your address, Mr. Claxton?
I live in Nisbet Settlement, St. James's Parish.
What is your occupation, Mr. Claxton?
I am a fisherman and a music producer.
Mr. Claxton, could you please explain to the court why you are here today?
I was involved in a traffic accident on the 28th day of April 2018.
Do you recall that afternoon, say around 2:15 p.m.?
Yes, my lord.
What, if anything, happened around that time?
I was heading to the airport to drop off some CDs to a shop there.
What was the registration of the vehicle you were driving?
PA345.
What type of vehicle were you driving?
It was a Jeep.
Did you arrive at your destination?
No, my lord.
Why not?
As I came around the bend, I saw a pickup truck approaching me at a fast speed. I had no time to brake, although I did swerve to my left, but I still could not avoid a collision.
Where did the accident happen?
It happened on the Island Main Road.
How often have you driven on that road in the past?
Quite a few times.
How many lanes are there on that road?
There are 2 lanes.
Can you please describe to the court what the road looked like?
There was a bend on the road.
What were the conditions of the roads at that time?
It was a paved road with very few potholes.
What were the weather conditions on that day?
The weather conditions was fair.
Can you describe the bend?
It was a slight right-hand bend.
Can you recall at what miles per hour you were traveling at around the bend?
I was driving at about 27 miles per hour.
And which side of the road was the other vehicle traveling on?
Traveling on the right side of the road.
At what speed would you say that the claimant was driving at?
The other driver was driving at about 70 miles per hour.
How far away was the vehicle when you first saw it?
Not very far away, because he was driving at a very fast speed.
Explain what you observed about the other vehicle when you saw it.
He was driving on my side of the road.
How did the claimant's vehicle approach you?
It approached me at a very fast speed.
Upon seeing the vehicle, what, if any, actions did you take?
I swerved to my left.
Did you manage to get out of the way?
No, I could not. No.
Since you were unable to get out of the way, what, if anything, happened?
I was involved in a head-on collision with the other driver.
Where was your vehicle hit?
It was hit in the front.
Did you observe your vehicle and the other driver's vehicle?
Yes, I did.
On the outside, what, if anything, could you see on your vehicle?
There was damage to my front.
How badly was your vehicle damaged?
There was extensive damage to my front bumper.
Was anyone else with you at the time of the accident?
No, my lord.
What, if anything, happened to the driver of the other vehicle?
He was pinned by his pickup truck.
What, if anything, took place after the accident happened?
I called the police and they told me to call the fire brigade. When they arrived at least 5 minutes after, and they removed him and left, and the police never showed.
Who, if anyone else, did you contact?
I called Mr. Nisbet.
Who is Philip Nisbet?
Philip Nisbet is a friend of mine.
How long have you known him for?
Quite a long time.
What, if anything, happened after you spoke with Mr. Nisbet?
Me and Mr. Philip, Mr. Nisbet, took his vehicle back home to his residence, and I took a taxi from there.
What, if anything, happened next?
Nothing happened next.
Thank you, Mr. Claxton. No further questions, my lord. If I can be of no further assistance to the court, those are my questions.
Yes, thank you very much. Any cross-examination of this witness?
Mr. Claxton, on the day in question, you had a few errands to run.
Yes, I did.
So, And different places to stop off at, I'm sure.
Yes, I did.
Right. So you were very busy that day.
I guess you
Yes,
can say that.
You were very busy that day.
Yes.
Understand. So you wanted to complete your errands very quickly, not so?
Not really.
You did not want to complete your errands quickly.
I was not rushing, but no.
Fair enough. So you were not in a hurry.
No.
Can I ask you a question? Mr. Claxton, would you say that it's easy to speed on a road with very few potholes, a nice smooth road? Would you say it's easy to speed or to drive fast?
I wouldn't know.
You wouldn't?
No.
It's funny. So you weren't the one speeding in question? Speeding on the day in question?
No, I wasn't.
Mr. Claxton, I'm putting it to you that you were the one speeding on the day in question because my client, Mr. Liebert, was stationary. Mr. Claxton, you said when you came around the corner, the pickup truck was on your side.
Yes, I did.
Your left-hand side of the road.
No, my right-hand side of the
Right?
road.
Okay. So he was pulling over on your side of the road.
He was driving very fast on my side of the road.
And to avoid a collision with Mr. Liebert's pickup, you swerved left.
Yes, I did, my lord.
But Mr. Claxton, if this is so, if this is, the evidence states that the collision was a head-on collision. If you were swerving left, how is it possible that your vehicle hit him head-on? If you were swerving left, as you said you were.
I don't know.
So you swerving left, did you run into a tree, a house, or the airport, anything such?
I swerved. I had a head-on collision with Mr. Liebert's vehicle.
So what was on your left?
The other side of the road.
But wasn't the airport on your left as said in the case evidence?
Excuse me?
If you were driving, wouldn't the airport be on your left? Wasn't the airport on your left? If you're coming from town, on the left-hand side of the road...
I was on the right-hand side of the road.
You were on the right-hand side of the road.
Yes, I was.
So that means you hit Mr. Liebert on the right-hand side of the road, which is the mountainside, head on.
Yes, I did.
Oh. No further questions.
Yes, any re-examination?
Excuse me, Mr. Claxton. What was on the left-hand side of the road? No further questions, my lord.
Well, you might want for her to answer that one before you decide that. No? You have an answer for your attorney? What was the last question you asked her?
I asked her whether the accident took place at the left-hand side.
You
of
asked
the
her
road.
whether the airport was on her left side. Was the airport on your left side?
No, my lord.
Yes, that's all?
No further questions, my lord.
Yes. Yes, any other witness for the defense?
The defense would like to call Philip Nisbet to the stand. Philip, please.
You tell me right. I swear that the evidence that I shall give to the court shall be the truth, the whole truth, and nothing but the truth. So help me God.
Could you please state your name for the court?
Philip Nisbet,
Mr. Nisbet, where do you reside at?
Spring Hill Estate.
May I ask what is your occupation?
I work with the offices in Charleston.
Mr. Nisbet, why are you here today?
Because my vehicle was in an accident.
What is the registration number of your vehicle?
PH345.
When did this accident occur?
On April the 28th, 2018.
And Mr. Nisbet, where did this accident take place?
In the vicinity of the Vance W. Amory International Airport.
And who was involved in this collision?
John Lyward and Kishan Claxton.
How did you know about the accident?
Mr. Claxton called me.
How do you know Mr. Claxton?
We've been friends for several years
And why did he call you about the accident?
because it was my vehicle.
So, is this the first time Mr. Claxton has borrowed your vehicle?
No, I lent him other times.
So, Mr. Claxton have drove on that road several times?
Yes.
What, if anything, happened after you received the call?
I went to the scene.
And what happened next?
I approached Mr. Claxton.
Mr. Nisbet, how long did it take you to arrive at the scene?
About 5 to 10 minutes.
Where were you when you received the phone call?
I was at home.
What, if anything, did you notice about the scene?
A dozen of people gathered around a pickup truck that was in the road.
Did you see your vehicle?
Yes, I did. It was on the south shoulder.
And Mr. Nisbet, what did you observe?
That Mr. Claxton was shaking and he couldn't explain what happened to me.
Did you notice anything else on the scene?
No.
Who, if anybody, did you interact with at the scene?
Only Mr. Claxton.
Is there anything else you noticed at the scene you would like to tell the board?
Even though my car was wrecked, it could still be driven.
What happened thereafter?
Mr. Claxton drove the car home.
What, if anything, did you do with the damaged vehicle?
I sent it to be repaired.
Where did you get this repair?
At Mohan Services.
Did you get the vehicle? Sorry. Did you perforate? Sorry, Mr. Claxton?
Yes, I did.
Mr. Nisbet, sorry?
Yes, I did.
Do you have proof that this vehicle was fixed?
Yes.
And what was the cost of it?
$100,000.
What is the date on the receipt?
July the 1st.
If you to be shown the document, would you be able to identify it?
Yes.
How would you be able to identify it?
It has on my car registration number and my signature.
My lord, my Mr. Nisbet be shown the document.
Yes. Is there any objection to the witness being shown the document? Very well. Counsel, you may proceed.
Yes, my
Oh,
lord.
there is. I'm sorry.
The mechanic is not here to give evidence to that, sir. So it cannot be verified.
Yes, very well. Let me hear what the other side has to say about it.
My lord, this is the issued receipt, and we rely on it heavily to carry on with our business.
Did the other side had a copy of this document before today?
Excuse me?
Did you give the other side a copy of this document before today?
No.
And why did you not give them a copy so that they would have been prepared to deal with this matter today? Can I have a look at the document?
My lord, if I may please.
Yes.
The receipt does not specify the repairs to the vehicle. It just gives a total sum of the repairs.
That's a very high sum as well.
will take the court's guidance and rely on the oral evidence of our witness.
Yes, if the document had not been disclosed before today and it doesn't seem to comply with any of the rules, so I would be confined to determining that the document is not admissible. So you'd have to proceed without it.
May I ask how much was paid?
The 100,000.
What other costs, if any, did you incur?
I had to rent a car.
What is the cost of the renting?
$40,000.
And for the time period?
From the 29th of April to July the 1st.
And what's the total amount for your loss of use?
$140,000.
For the rental.
40,000.
Have you had your vehicle repaired?
Yes.
And on what date did you get back your vehicle?
July the 1st.
And at what time did you return the rental?
About 11 a.m.
On what date?
July the 1st.
Thank you. No further questions. No further.
Okay, I'll make it come down. Just no further question.
Excuse me. What further amount are you claiming for?
$140,000.
And that's because?
Because of my vehicle and the rental.
So that's the price combined?
Yes.
No further questions.
Yes. Any cross-examination of this witness?
Yes, please. Yes, my lord. Sorry. Mr. Nisbet, are you the rightful owner of vehicle PA 345?
Yes.
So, would you say you have a personal interest in having it repaired?
Yeah.
Okay, on the 28th of April 2018, you said you received a phone call from Mr. Claxton telling you he was involved in an accident, correct?
Yes.
And was the vehicle insured at the time of the accident?
Yes.
Mr. Nisbet, would you say Mr. Claxton is your close friend?
Yes.
So, how long have you known Mr. Claxton?
About 10 years.
So, would you say you know Mr. Claxton's voice, correct?
Yes.
So, it would be highly unlikely that you would be confused about who you spoke to on the phone that day, correct?
Yeah.
But in your witness statement, on one hand, you said Mr. Claxton called and told you about the accident, but on the other hand, you said Mr. James. So which is it, Mr. Nisbet?
Mr. Claxton.
So who is Mr. James?
I really don't know.
So who is... So why did you put it in your report? In your witness statement?
Maybe it was a typo.
Maybe, or it wasn't?
It was.
Did Mr. Claxton speak clearly to you on the phone when the accident happened?
Yes.
So would you say he was calm and coherent?
No, not exactly, but you know, yeah.
How did he sound on the phone?
He was overwhelmed, but he spoke clearly.
At what time did you receive this call from Mr. Claxton on the day of the accident?
Around 1 p.m.
Around 1? In your statement, you said, in Mr. Claxton's statement, the accident happened around 2:15 p.m. And you're saying now that you received the call at 1 p.m. Was the call about something else, or?
Maybe my phone had the wrong time.
That's highly unlikely.
Because?
Okay, in your statement, you stated that you arrived at the scene of the accident 5 to 10 minutes after you received the call about the accident. Mr. Claxton is supposed to be a close friend. What took you so long?
The road was busy.
In Nevis?
Yeah.
When you arrived, you said you noticed the pickup truck in the road, correct?
Yes.
And Mr. Liebert was not in the truck, was he?
No, don't recall seeing him.
In fact, by the time you got to the accident, the fireman had already cut him out of the truck and your Jeep had already been moved. So you can't speak about the impact because you never saw it. So how could you give a statement and you know nothing about it?
Yes, counsel, you
Argumentative?
one question at a time. Yes.
Sorry.
Thank you.
So how could you give a statement you know nothing about?
I have to answer that question.
By the time you got to the accident, the fireman had already cut him out of his truck, correct?
I would assume.
And your Jeep had already been moved, correct?
No, I saw my Jeep. It was on the staff shoulder.
But in your statement, you said that your Jeep had already been moved by the time you got at the accident.
That's not what I said. I said I saw my Jeep on the staff shoulder.
Mr. Nisbet, I am putting it to you. You can't speak about an impact that you never saw. So how could you give a statement you know nothing about?
Who says I...
You said that Mr. Liebert caused the accident. How did you know that he caused the accident if you were never there? You were there.
Objection. My witness did saw the accident. Sorry. My witness did not say he saw the accident, but when he I will let my witness give the evidence.
Yes. I think that will be best. Yes, carry on.
My Lord, may the witness please read her last paragraph in her witness statement.
Yes, does she have a copy of it?
ask no one. Repeat what you tell me though? What?
Please read the last paragraph of your witness statement.
You mean from the repairs? Right on.
The last paragraph. Yeah, that's one. The repairs, yes.
Okay. The repairs to my vehicle took several weeks and
Please
cost.
speak into the mic.
The repairs of my vehicle took several weeks and cost $40,000, and I am claiming this sum as Mr. James was not the cause of the accident.
So how do you know that Mr. James Nisbet is not the cause of the accident?
A wild guess? I don't know.
A wild guess? Or are you just covering for your friend?
No.
In your statement, you said that when you saw Mr. Claxton, he was visibly shaken and had difficulty explaining what happened, correct?
Yes.
So how could you base your statement off of what the first defendant can barely explain?
Because he is my good friend and he wouldn't lie to me.
So because he's your good friend, you come into this court telling lies.
No.
I am putting it to you that Mr. Claxton's version of the events may not be accurate.
They are.
How do you know that they are accurate?
I was just...
Because he was visibly shaken. So how do you know that they are accurate?
He wouldn't lie to me.
Are you sure?
Yes, I'm positive.
But he didn't explain himself. So how could you write up a whole witness statement if he couldn't explain himself properly? Okay, moving on. Just to clarify again, you said Mr. Claxton was visibly shaken and had difficulty communicating. But yet you allowed him in his condition to drive the vehicle to your home in Spring Hill, correct?
Yes.
But wasn't it necessary for him to see a doctor if he's in that condition? Yes or no?
Yeah.
So why didn't he go to the hospital instead of driving your vehicle home in his condition?
Objection.
That's what he wanted to do.
She cannot possibly know what's in the mind of Mr. Williams. Mr. Claxton.
Yes.
Yes, but she's giving the evidence of what Mr. Claxton told him.
Exactly.
Yes, but continue. Let's hear what he has to say.
I am putting it to you that Mr. Claxton was not shaken and that you are not being truthful. And you would say anything to cover. I am putting it to you that Mr. Claxton was not shaken and you are not being truthful.
I am being truthful.
But you would say anything to cover for Mr. Claxton because he is your close friend. It's a yes or no question, Mr. Nisbet.
No.
I put it to you that you would cover for Mr. Claxton, especially now that the consequences can personally affect you. Am I correct?
No.
No further questions, my lord.
Thank you.
Yes. Any re-examination?
No re-examination.
Thank you, Mr. Nisbet.
No problem.
You can step down. Are there any other witnesses for the defense?
That is the case for the defendant.
Yes. The parties ready with their closing submissions at this stage?
Yes, please, my lord.
Yes.
May it please you, my lord. This is a simple case of negligence. The first defendant on the 28th day of April 2018 was negligent in that he drove fast and recklessly without due care and attention, causing a collision that resulted in serious injury, loss, and damages to the claimant. In the case brought forth to the court, the claimant, John Liebert, was driving his motor vehicle along the Island Main Road near to the Vance Army International Airport on the date aforementioned. Mr. Liebert was traveling in the direction from the Newcastle to Charlestown with one passenger named Mr. Pringle, who was an employee on his farm. Mr. Pringle was traveling on the tray of the pickup truck, sitting on the top of the feed, which they were going to deliver. While driving, Mr. Liebert noticed that it was about to rain, and so he stopped on his legal side of the road, the mountain side of the road. Immediately as he stopped, a vehicle speedily came around the bend on Mr. Liebert's side of the road, which is the mountain side of the road, and collided head-on into the pickup truck. The accident happened so quickly that Mr. Liebert didn't have any time to escape the collision. It was a head-on collision. The first defendant, who was driving the second defendant's vehicle at the time, hit with such a force that the Jeep climbed right on top the claimant's pickup truck, leaving Mr. Liebert in great pain and his legs pinned to his vehicle. The claimant was in great pain and distress, but he vaguely remembered before he passed out someone trying to free him from the wreck. The record will show, however, that this was not successful, as he had to be freed by the jaws of life by the fire department. Mr. Liebert woke up in the Alexandra Hospital and was later flown out to Trinidad by an air ambulance, as his injuries were too extensive for the local care. His extensive medical treatment has left him with enormous medical and financial expenses. In fact, 1, his brand new specially equipped pickup truck is totally wrecked and cannot be easily equipped. 2, are replaced. 2, his farm is in a financial mess. He has not been able to return to work and had to lay off his worker so that he could keep the farm going. He has had to purchase a wheelchair, take physical therapy sessions, and also continues to incur medical expenses daily. The defendant has filed a counterclaim claiming $140,000 for the damage of the second defendant's vehicle, on this basis that the claimant caused the collision. But this claim is totally unfounded and is riddled with glaring inconsistencies. These inconsistencies are: 1, the defendant alleges that on the day in question, the claimant was driving at a fast speed on the wrong side of the road as though he was about to pull over on the short shoulder. My lord, permit me to raise a question. How can a vehicle be driving fast if it looks like it was slowing over? That doesn't sound right to me. Secondly, the first defendant says that he was driving at 45 miles per kilometer on a paved road with very few potholes. If this were true, and he was driving at 40 kilometers and aware of the claimant's position on the side of the road or on the road, he would have been able to swerve to the left or even move right to avoid the collision. Thirdly, if these 2 points were true, the least that would have happened, my lord, was that the 2 vehicles would have brushed each other on the side or even caused a side impact collision. But the evidence shows that this was a head-on collision. But the witness states in his statement that he swerved left. My lord, if the witness swerved left, wouldn't he drive right into the airport? Certainly the defendant's version of the fact cannot be true. Fourthly, the second defendant states in his witness the second defendant's witness statement is of no moment. It is clear that the evidence of the second defendant served no useful purpose in this case here today. And he is only here to advance his personal financial interest in this matter. In Mr. Leiber's statement, he stated, and I quote, "The repairs of my vehicle took several weeks and a cost of $40,000. I am claiming this sum for Mr. James." My lord, Mr. James was not the cause of the accident. My lord, this sum is not supported. One moment he says it's 40,000, and the other moment he says 140,000. He needs to make up his mind. The second defendant cannot say who caused the accident. The second defendant cannot even say who called him about the accident. Was it one, Mr. James, or was it Mr. Claxton? My lord, Mr. Nisbet came here today and lied to the court. My lord, even his body language suggested that he wasn't telling the truth. Furthermore, the second defendant says in his statement that the first defendant was shaking and had a difficulty explaining what happened to him. Yet still, the first defendant, in the condition he was in, drove the same vehicle to the second defendant's home after the accident. This offends all basic knowledge, my lord. We say he was covering for Mr. Claxton. My lord, the evidence states, or the evidence speaks for itself. The defendant's counterclaim should be dismissed, and the claimant should be awarded the relief he seeks as he results in this unfortunate accident. My lord, the first defendant has admitted that it was a head-on collision and he was on the right side of the road, which means that he collided with the claimant and who was stationary on the side of the road already. The defendant also states that there was no airport on the left side of the road. My lord, this is clearly untrue. The first defendant isn't really associated around the area. He doesn't really know the area. For a claim of this nature to succeed, the claimant must prove that there was a duty of care, that duty was breached, and the breach caused the claimant harm. The claimant has led sufficient evidence showing that each of these elements has been proven. My lord, unless I can be of any further assistance, this is the end of my closing statement.
Yes, perhaps you can assist me a little bit. What about Mr. Pringle? Where was he at the time?
Mr. Pringle?
Yes.
At the time of the collision or after the collision?
At the time of the collision, where in the vehicle was he?
Mr. Pringle was to the back of Mr. Leibert's vehicle.
Would you say that was a safe place for him to be?
Well,
if he was sitting on it, it was. Because he said in his witness statement, yes, it was a boom, but he was able to hold on to the pickup. So there was a bit of security there.
So why, if the two of them alone were in this vehicle, why was he sitting in the trunk as opposed to...
Because there were a lot of information, important information on the seat, and he had no problem going behind there because he didn't tell Mr. Liebert anything.
And secondly, perhaps you can help me with that as well. Even if Mr. Liebert was on his side of the road, should he have stopped his vehicle so close to a corner?
He was 50 feet away from the corner, giving the defendant enough room to turn on his side.
Yes. Very well.
Thank you,
very
my lord.
much. Yes. Closing submissions from the defense.
As a reminder, my lord, my name is Maya Grant, and I will now address you on behalf of the first and second defendants. My lord, when one is hasty, the results are quite often dangerous. We submit that this is what occurred on the 28th April 2018, the day of the collision. My lord, this case is one of negligence and complete failure to comply with the rules of the road. The incident came about as a result of an individual's lack of concern and well-being of his fellow road users, an utter disregard for the safety of other human beings while driving along the Island Main Road. From the evidence presented today, we submit that the individual is in fact the claimant, John Liebert, and not the first defendant. We have summarized the issues that the court is called upon to consider as follows. 1. Did the parties owe a duty to each other as road users? 2. Was there a breach of duty, and by whom? To answer this question, the following will be considered: whether the claimant was driving at an excessive speed, whether the claimant was driving on the incorrect side of the road, whether the claimant was stationary while the collision occurred, whether the claimant failed to brake, swerve, or steer, or even maneuver his vehicle to avoid the collision. 3. Was the damage a result of the breach, and to whom? 4. Who should be held liable for said damages? 5. Whether there was contributory negligence. 1. Duty. The first issue is whether the duty was owed by the claimant and the first defendant as road users to drive with responsible care and attention. It is submitted that based on the pleading, it is accepted by all parties that both claimant and first defendant as road users owed each other as well as other road users a general duty to drive responsibly, with care and attention, so avoid collision. My lord, as this is not an issue in dispute, we can proceed to address the other issues before the court. 2. Breach of duty. My lord, it is submitted that on behalf of the first and second defendant that the claimant is liable for the accident. My lord, the claimant contends that the first defendant, Mr. Kishon Clarkson, is the one responsible for the collision, and that it was the first defendant who was negligent in his driving. However, the defense have shown that the claimant, in fact, was a negligent party. My lord, the first defendant, Mr. Kishon Clarkson, gave evidence that on the 28th of April 2018, he was on his way to the Newcastle airport to drop off some CDs at a shop
there to be sold. On arriving near the Vance W. Amri International Airport, he saw a vehicle, a pickup truck driving at a fast speed on his side of the road, though the driver was pulling over to the soft shoulder. However, before he could arrive to his destination, he was involved in a collision with the claimant. My lord, the evidence that the claimant, John Liebert, were coming around the bend along the Island Main Road near the Vance W. Amri International Airport attempted to stop his vehicle after noticing what he thought was afraid. The evidence of Mr. Liebert is that he wanted to cover Mr. Pringle, who was traveling on the back of his truck, as well as his feet, so that it would not get wet. Mr. Liebert, in his examination of Chief, seems to be paying more attention to the weather rather than focusing on the road. This, we believe, caused Mr. Liebert knowingly to veer onto the incorrect side of the road, colliding with the vehicle driven by the first defendant, Mr. Claxton. In our case, based on the evidence presented today, that the claimant had been paying attention to the road and other road users, he might have been able to make the necessary action to slow down in time and avoid the collision with our client. The second issue is that the claimant was driving at an excessive speed. The claimant is contending with the first defendant was the one driving at an excessive speed, but the defense has shown that it was in fact the claimant driving at a fast speed. The evidence of Mr. Liebert is that he noticed it was about to rain and stopped on his side of the road. However, it is evidence of Keyshawn Claxton is that he was traveling at about 45 miles per kilometer or 27 miles per hour as he came around the slight hand bend in the road. He saw a pickup truck driving at a fast speed and driving on his side of the road, as though the driver was pulling over to the soft shoulder. My lord, we submit that if the claimant had in fact veered to the wrong side of the road, then it is most likely that not to realize this, the claimant would have sought to increase speed to avoid oncoming traffic. Unfortunately, my lord, Mr. Liebert would have been misjudged his ability to clear the road and such collided with our client. My lord, this leads me to the third submission. That is, that the claimant was driving on the incorrect side of the road. My lord, the first defendant gave evidence that when he came around the bend, he realized that the claimant was on his side of the road. Due to the claimant's fast speed coming around the bend, the claimant ended up on our client's side of the road, coming straight for him. For this reason, my lord, although our client implied his best efforts to get out of the way of the claimant's vehicle, it still remained impossible for the collision to take place. My lord, this was a clear and inevitable accident. The principle was discussed in Javier Arton et al. And Winston Skeet et al. Claim number NEVHCV 24/2007 at paragraph 30, Projustive Octave. My lord, may you please I also gave the other side copies.
Yes.
Where a defendant relies on the defense of inevitable accident, he must prove that some reason beyond his personal control and even his skill and care, the accident or skidding could not have been avoided, and at that he was not negligent. In accordance with the said principle, the defense has proven that for reasons beyond the client's control, although he swerved to the left to try to escape the collision, the accident could not have been avoided as such. He was not negligent. The fourth submission is that the claimant was not stationary when the collision occurred. The claimant said in his court examination in chief that he was stationary. My lord, the defense contends that the claimant was not stationary. The credibility of the claimant called into question because it was impossible for the claimant to have been stationary since he was driving at an excessive speed onto the incorrect side of the road. In River case, paragraph 16, the court has relied on the principle laid down by Lord Pierce in his House of Lords decision of Onassis and Burgos, 1968, to Lloyd Rep 403 at P431, which offered compliant guidance on assisting witness credibility. It states, credibility involves whether the witness appears to be telling the truth as he is now believed it to be. Credibility covers the following problems. First, the witness is truthful or untruthful. Secondly, is he, though a truthful person telling something less than the truth on the issue, or ought to be an untruthful person telling the truth on the issue. Thirdly, though his truthful person is telling the truth as he sees it, did he register the intentions of the conversation? And if so, has memory correctly retained them? Therefore, my lord, the court must carefully consider the conjunction with the statement made by the claimant, to ascertain whether or not he is in fact telling the truth. We strongly submit and hold the position that the claimant was not stationary at the time of the collision. Our next submission is that our belief is that the claimant failed to brake, steer, swerve, or even maneuver his vehicle as to avoid a collision. The defense submits that the claimant failed to brake, steer, swerve, or maneuver his vehicle so to avoid the collision as a result. He breached the duty to care which owed him to my clients and also other road users. Pursuant to Section 48 of Vehicle and Road Traffic Act, Chapter 1506, SKM. Any person who drives a motor vehicle on the road recklessly or at a speed or in a manner which is dangerous to the public have regard to all the circumstances of the case, including the nature, condition and use of the road and the amount of traffic which it is actually at the time, or which might reasonably be expected to be on the road. Commits an offense. Additionally, The claimant is breach of Section 49 of the Act, as mentioned since he drove. Since he drove without due care, attention, or reasonable consideration for other persons using the road. My lord, the claimant should have been proceeding with caution by not adhering to the rules of the road. The claimant risked and endangered the safety of both the public and himself and caused damages to both vehicles. Thus, we submit that there is no excuse for the claimant's failure to avoid the collision. Damages. It is our submission that the accident was due to the negligence of the claimant and not of the first defendant, and the claim ought to be dismissed against all clients. Additionally, we submit that the claimant's negligence would have resulted in damages to our client. Such damage include the cost to repair said vehicle in the sum of $100,000. Mr. Nisbet has proven to the court. Mr. Nisbet gave evidence that his vehicle was unable to be driven. As such, he had to rent a vehicle. In this regard, our client submits that he has not extended the sum of $40,000 towards the cost of a rental until his vehicle was repaired. Mr. Nisbet has provided the court with while we stand firm in our conviction, the accident was due to the negligence of the claimant. If it is that the court finds our client somehow drive negligently, we submit that any damages award to the claimant should be reduced to the claimant's own contributory negligence. My lord, the defense contends that our client was not negligent. However, in the event that the court is minded that the claimant is not fully liable, I will now address the issue of contributory negligence. My lord, the defense submits that the act our client took place in swerving to the left in attempt to prevent the accident from happening. However, the claimant failed to avoid collision as stated before, which resulted in him also suffering injuries. The law is clear on the matter of contributory negligence, and in Ramnath and Avisto Civil Appeal number 9 of 1996-1997, Justice of Appeal Singh stated as page 5. It is accepted the guiding principle of providing contributory negligence is whether the respondent, by his act or omission, contributed to his injuries in the sense that he failed to take responsible care for his own safety, taking into account as he must that other users of the road are likely to be negligent. It is therefore submitted that the claimant failed to take responsible care for his own safety when veering onto the wrong side of the road and into the path of Mr. Claxton. Additionally, there is no evidence that Mr. Liebert wore a seatbelt, which could have reduced the impact to his injuries. As such, we submit that the claimant was in fact contributory negligent
and any damages awarded ought to be reduced by 90% based on the action of the claimant. My Lord, our clients have been subjected to hurrying the process because of the claimant's negligence and hasty action on the road. As such, my Lord, the evidence is quite clear. Our client exercised proper road safety. He did his best in attempt to prevent the collision from happening. Neither my client nor any other road users could have apprehended the claimant coming around the bend with so much speed and on the wrong side of the road. My Lord, there is an old proverb saying, there's the old proverb that says, hurry man just eat raw meat, which is why the claimant was now found himself in such a predicament. Therefore, my Lord, the defense asks that this honorable court finds the accident caused by the negligence of the claimant and dismiss the claim of the claimant. My Lord, we ask this honorable court to grant the damages paid for by the counterclaim on behalf of the second defendant, with interest and cost to defend. May it please you, my Lord.
Yes, no, don't sit just yet. Let me just ask you a couple of questions. Given that your client accepted that she was on the right, was on the right side of the road, that would effectively have put him on the wrong side, no? Cross-examination. If he's coming from Charlestown direction, that's what you were suggesting? And he admitted in cross-examination that he was on the right side of the road. That would have put him on the side that he was not supposed to be.
My client did not understand the question clearly. So therefore, he made a mistake.
Are you giving the evidence for the client? So that would have put him on the wrong side. And given that he could not remember all that much, that made him a very unreliable witness, wasn't he? Would you not agree with me?
I beg to differ.
Very well, you may have a seat. That is all?
Yes, my Lord.
Yes. All right. Before I give a ruling on this, I suppose for a moment we can take off our acting hats. Let me welcome you, the six formers, and I suppose other persons to this courthouse. My understanding from the research that I've done is that it's actually one of the oldest courthouses still standing across the Eastern Caribbean. So it comes with a lot of history, and it's my pleasure as the presiding judge in Nevis to welcome you to the court. You don't have to be strangers to it, because we employ what we call an open court process, meaning that whilst court is taking place, anyone is supposed to be able to come and sit in the gallery and see what's going on. So if any of you have an interest in eventually studying law and becoming lawyers, you can always feel free to come and see what's going on. So I would invite you to do that once in a while. It was a pleasure presiding over the proceedings. It's a lot lighter than what's going on right now. We're in criminal assizes, so we handle the cases and everything else. So it was a pleasure to do something a little lighter. Although whilst I refer to it as being lighter, I don't know anywhere in the world that Dodge Ram would cost $450,000. But if I can just say that I was quite impressed with your ability to to present your cases, both in terms of the examination in chief and the cross-examination. I found that all of you, each of you have a different style, and that's all right. In fact, that's what makes it exciting. And to be able to communicate, whether it's with a witness or with each other in your own way, is something that you will continue to harness over time. The cross-examination was particularly exciting, especially the cross-examination of Mr. Claxton, who couldn't remember all that much. But I found that all of you were able to think on your feet and think of the right questions that you needed to ask. The only challenge, obviously, is doing it slow enough so that the judge can write. I'm still praying for the day when the judge does not have to write. We can record things and get, but in the old way of doing things, the judge literally has to write everything, and you have to take a lot of time. But you're young, and then I thought that your presentations were good enough, so I think that you have a lot to be proud of. I can just make one observation, in that there are 8 of you presenting, and there's only one male. And from what I understand in our law schools all over the Caribbean now, the women are taking over. So pretty soon it'll be a very rare species. As a matter of fact, it's already getting to the point where if you attend the magistrate's court or a high court in the Caribbean, you're more likely to appear before a female magistrate or a female judge. And so persons like myself are becoming a rarity. We'll see whether that's a good or... it's good in the sense that we see more of our ladies, taking up these roles that they didn't traditionally. But sometimes it does scare me a little bit that the men are becoming scarce. It's not just in law, but in many other... if you go to universities these days, our men are not going as much as our women are. So that's something to think about. So to the only... I don't know whether it's the thorn among roses or whatever it is, but to the gentleman who presented, I think you did a wonderful job, and hopefully you can drag more of your friends with you. So again, welcome you to the court. I hope you had a good time. I certainly enjoyed sitting and listening to the presentation. Insofar as the case was concerned, each of the cases obviously had their strengths and their weaknesses. The obvious weakness for the claimant's case was that he had taken a decision to park his vehicle somewhere around the corner. It's actually illegal for somebody to be in the boot of a vehicle like that. So the passenger should have actually been inside and not in the boot. He obviously said that he had stopped because he thought it was going to rain, but the passenger who was outside didn't notice any rain, and I don't see anything in the evidence that tells me rain fell even after the accident took place. So as to why he stopped, or whether you can rely on the fact that but I think there's sufficient evidence here to suggest that he had stopped his vehicle. Perhaps a little too close to the corner, but he had stopped nonetheless. So I would find that when the accident took place, he was stationary. And if he was stationary, it means that some way, shape or form, the other vehicle ran into him. The obvious weakness of the defense case is that the witness accepted in evidence that he was driving on the wrong side of the road. I don't know what he was doing there, but obviously if he had swerved left, if he was driving on his left side and if he had swerved left, as he said, he would have ended up off the road. So it's obvious that he came around the corner on the wrong side of the road. And he made a very unreliable witness as well, in terms of not being able to remember all that much. So these are the issues, and I think that you were able to identify the issues. The irony is that whilst there was an objection to the defendant putting in his estimate of repairs, the claimant is claiming a very high sum for a vehicle, and he presented no evidence as to the value of his vehicle. So it would be difficult to determine exactly what the damages are. But I would not leave him without damages. I would leave him with what I would call a nominal sum. I really want to see the Dodge Ram that cost so much money, because this case, is $40,000 in rental, $100,000 in repairs. But I would rule in favor of the claimant. I would, however, also rule that the claimant would be at least 20% negligent in parking where he parked. So the defendant will pay 80% of the damages. I don't accept that the vehicle cost $450,000. I would estimate the value of a Dodge Ram to be $100,000. And given that it was a vehicle that was already a couple of years old, I would depreciate that from $100,000 to $80,000. And I would award him that sum. I would give him the cost of the wheelchair, because despite the cross-examination of the doctor, I would accept the doctor's evidence that he needed a wheelchair and the other medical expenses that he has. I don't know that he would have spent $4,000 a month on his farm, so I would reduce that from $4,000 to $2,000. Given the nature of his medical expenses, for which he provided absolutely no invoices at all, I would also reduce that to $100,000. And so, having made these reductions, I would find that the defendant, the first defendant, well, the defendants will be liable to pay 80% of the award that I have given to the claimant. The claimant will be responsible for 20%. I will give the claimant his costs. So that means you would have to split costs among the four of you and the two, the two coaches. And interest at the rate of 6% on the damages that I have given to him. And unless I can be of any further assistance to you, thank you for being here. I did enjoy my time, and I wish you all the best. Thank you very much.
Order, all stand. This round of court now stand adjourned. I'll take Green and this round of court.
Thank you.
That's it.
Thank you for helping us. Thank you for helping us. Thank you. Thank you for helping us.